Hodgson said there's no controversy yet. He said that I'm not going to rule on it. I'm not going to do anything, and let's see what happens.
Okay. So basically, you had a last ditch.
To the extent it mischaracterizes a court ruling, that's not what was said. And if there is a ruling, that should be in evidence, not Ben's subjective interpretation of what may have been said.
Ben, is it fair to say that your lawyers right at the foreclosure sale tried to get the Lakeview lot money released so you could save the property?
Yes.
And that failed, right?
Yes.
Okay. Now, so you went and you bought the property, and what name did you buy it in?
Well, I didn't think I was going to win, so I had no entity set up. I got there and I just basically put the contract in Armstrong Capital's name. That's my mother company that I've had for 25 years.
And what'd you buy it in?
So later on, we created a new LLC called Sunset Hill Oak Ridge Plaza LLC.
Okay. Do you still own it in that name?
Yes.
Okay. And are you 100% owner?
No, my kids own most of it.
When did you give it to your kids?
My kids put up the money to buy it.
Well, I thought you told me that you borrowed about $1.5 million from the democracy lender.
I have to go through the closing statement. We had to come up, there was like 8 points on that loan. There was like, we had to come up with about $500,000 in cash.
Okay.
And also, so I came up with the deposit, I think was 20%. I forgot what the law is in New Jersey, but I think it was 20% of the purchase price to put up in certified checks at the foreclosure sale. So that money came from my kids.
Okay. So what percentage do you own at this point?
I own 10%, and my wife owns 10%, and the rest is the kids.
Okay. And is that property throwing off monies at this point? Is it
No, we still have the hard money loan on it, and there's a lis pendens against it. So there's a Hana's lawsuit. I can't refinance it.
So Hana filed a lis pendens against it?
Judge Hodgson put a lis pendens on it after she filed her lawsuit, and we tried to remove it, and Judge Hodgson was like, well, let's just, after the trial, we'll deal with it.
All right, take a look at the exhibit number 36. And go to the third page, which says Democracy Capital.
Yeah.
And this apparently is a term sheet issued right at the time of the foreclosure sale.
Yeah. This is the loan. They only gave us $1.2 million. Yeah.
All right. And that appears to be your entity, BCR Oak Ridge. Is that your entity?
No, that was the entity me and Hana had together that was the borrower back then. That was our entity. This loan commitment is the loan I mentioned earlier, which I got to save the property from foreclosure.
Well, this is within days of the foreclosure. Or after the foreclosure, I think. Is this after the foreclosure or before?
Can we have a stipulation? Is there an can counsel on both sides agree on the date of the foreclosure sale?
Yeah, Ben, when was it?
I believe it is June 28th, and the report of the sheriff's sale is Exhibit P-214.
Okay.
So this is before the sale. This was Democracy Capital is my neighbor's.
Got it. Ben, was your sister advised of this potential lender before the sale? Yes or no?
Yes.
Did she refuse to go along with it? Yes or no?
Yes.
Okay. Let's look at 37. Could you tell me if this is the document? This appears to be the document where your mother was going to loan $1.35 million in order to save Oak Ridge. Was it?
This is the document, yes.
And did you sign it?
Yes.
Did Hana sign it?
She was the only one who did not sign it.
Okay. And that was done as of June 24, 4 days before the foreclosure, right?
Yes.
So you had arranged and worked this out. The agreement was drafted and you went along with it, but your sister did not, correct?
Correct.
Objection, leading, and again, the document itself doesn't have Charles Mandel's signature. So I know it's right for cross-examination, but when Ben says everyone but his sister signed it, it's demonstrably untrue.
Let's clarify. Let's talk about the principles and forget about the lawyers for a second. Did you agree and sign this document?
Sorry, what?
That's your signature, right?
Yes, it's my signature.
And you knew, did you not, that your sister refused to sign it, right?
Yes.
Let's look at, number 39.
Well, can we just have clarity if we're going to move off of 37? Who is Charles Mandel?
Can I answer that?
Yeah.
Charles Mandel was a trustee of the Clara Ringel Trust, and he was also my mother's lawyer in Lakewood, and he did sign it, and I can find the document and supplement the record if you want me to. He signed it as a trustee.
Let's do it as we go.
And let me just clarify one issue, Ben, if I could. Do you know if everybody had agreed to sign it other than Connor, whether we have the signatures on this document or not? Did everybody involved in the transaction, the Clara Ringel Trust, her lawyer, you, your lawyer, did everyone else agree to the deal except Connor?
Yes.
All right. Now we'll go to, can I move to 39?
Sure.
Let's go to 39, where your lawyer is advising Michael Cohn that you purchased the property. You see it in the first line?
Yeah, it was 2 days after the sale. Yes.
Okay. And it says, in quote, as you know, that foreclosure sale was caused by the consistent refusal of Connor Ringel to accept a loan on behalf of BCR's Lakewood to pay off the Flushing bank loan. Ben sought Connor's consent numerous times to save the property for the benefit of Oak Ridge and prevent a foreclosure. You see that?
Yes.
Do you know if Connor ever denied the assertion in this email by your lawyer that in fact you tried hard to get her to work with you and she refused? Did she ever in email, letter, or otherwise say, oh no, I was always willing to sign off, help you?
She never would agree to do anything to save the property.
Okay. Let's look at number 40. Is it fair to say, Exhibit 40, is it fair to say that days after you bought the Oak Ridge property, Connor filed suit against the Chancery?
Yes, in front of Judge Hodgson again.
Did Connor call you or say, Ben, we're blood. You're my brother. Let's sit down and try to work this out before I sue you again? Did you ever do that?
No.
And by the way, Ben, Oak Ridge, the agreement you had with Oak Ridge, which we started as P1, that agreement had an arbitration clause, did it not?
Yes.
Actually, Your Honor, we've been through this now multiple times. Mr. Ringel waived any right to arbitrate. The appellate division has already concluded that, and Your Honor has already found that that issue is now beyond the scope of this arbitration. I will note that they keep referring to an arbitration clause, and as we've argued to Judge Hodgson, the appellate division, and Your Honor, it's not. It's a deadlock provision, not an arbitration provision. But in any event, he's waived any rights under that contract, and any questions should be barred.
Judge, I know Your Honor made a ruling about claims, but the fact that the arbitration provision was not followed by a partner, there's a two-step procedure, a mediation and an arbitration. I think factually, I'm allowed to put that in the record. Even if Your Honor says I can't make a claim for it, I can show a breach as well as multiple breaches by Connor of the agreement. I think Your Honor has got to, at some point, make a decision as to whether there's a breach or not. Now, can you award damages for it? Your Honor said no, that's out of the case. But I think I can establish a factual breach.
My ruling is broader than that. We're not going to go into arbitration. We're not going to question the witness about arbitration. The issue has already been precluded. We have a limited time that we have agreed that this witness will be concluded. We don't have time to go on an issue that's already